Hey everyone, and welcome back. We're diving right into those UK real estate cases you guys sent in, the ones dealing with nuisance. Some really interesting rulings came out of the Supreme Court just this year, and we're going to break down two in particular, just to see what kind of impact they might have for property owners.
Yeah, it's fascinating stuff. So we've got Manchester Ship Canal Co. versus United Utilities. That's one. And then the second one is Davies versus Bridgend County Borough Council.
Okay, so two very different cases when you hear just the names like that, but I'm guessing there's a common thread somewhere in there.
Absolutely. At their core, both of these rulings really get to the heart of what it means to exercise your property rights and then, all the complexities of actually trying to get legal remedies when things go wrong.
Right, because proving something is one thing,
Sure.
but then actually getting a court to agree with you and actually give you some sort of
Compensation or...
or make it stop even sometimes, right?
Absolutely. And that's really what we're going to see play out in both these cases.
Okay, so let's dive into this first one then. Manchester Ship Canal Co. versus United Utilities. It sounds almost Shakespearean, doesn't it? Got this battle between like a canal owner and a big, powerful utility company over, of all things, sewage. You would think that would be pretty open and shut, right?
You would think. But this case, it really hinges on a really specific and unusual point of UK law that I think a lot of people, even those who follow these things closely, might not be aware of.
Okay, intrigue me.
So, you see, there's been this kind of assumption in past rulings that if you're going to sue a utility company over a nuisance, and the solution to that nuisance involves them having to really invest in their infrastructure, like a major overhaul, then historically, the courts have been reluctant to side with the individual property owner.
Interesting. So even if you could prove that it was the utility company's fault, the courts were basically saying, well, that's too bad, but we're not going to force them to rebuild their entire system just for you.
Yeah. Essentially, they were saying the power to make them fix something that big, that costly, that really rested with the regulator, not with an individual through a nuisance claim.
Okay. So in this case with the canal, the owner was basically expected to just appeal to Ofwat, that's the water regulator, right? And hope that they would force the utility company to clean up their act.
Exactly. That's the system as it was generally understood. But the Supreme Court, they really threw a curveball this time. They actually sided with the canal owner. And the reasoning behind it is, it's fascinating.
Okay, lay it on me. What was the logic there?
It all boiled down to a really important but subtle legal distinction. The law, as it was written, it didn't actually say that the utility company had a right to pollute. It just outlined the regulator's power to make them clean up the mess, if you will.
So the court kind of found a loophole, so to speak. They said, well, just because the regulator can step in, that doesn't mean the company is automatically off the hook for causing the problem in the first place.
That's a great way to put it. And that's a big deal. This decision sends a very clear message that companies can't just hide behind the fact that there's a regulator out there. They still have a responsibility, a legal responsibility to avoid causing harm, and they can be held accountable for that harm even if there's another avenue for seeking a remedy.
Which, for the canal owner, obviously a huge win. But it does make you think, what does this mean for the average person? I mean, we all live downstream from somebody, right? Sewage in the waterways, that's not just a problem for canal owners. It's an environmental issue that affects everyone.
That is the million-dollar question. And that's where things get really interesting because this ruling, as significant as it is for, owners of waterways, it doesn't directly translate to this kind of broader environmental protection. It doesn't automatically mean we're all going to have cleaner water now just because of this one case.
Right.
What it does do, though, is really highlight the potential limitations of relying solely on these kind of private nuisance claims when what we're really talking about are, these broader environmental concerns. That's going to require, probably a different approach, something more systemic.
Yeah, bigger than just one canal and one company, for sure.
Exactly.
All right, so from sewage-filled canals, let's move on to something a little, shall we say, less smelly, but arguably just as troublesome for property owners, Japanese knotweed. Always a fun one.
Ah, yes, the plant that can strike fear into the heart of even the most seasoned gardener.
Absolutely. And in this next case, Davies versus Bridgend County Borough Council, we see exactly why this invasive plant is so dreaded.
Oh, absolutely. This case really highlights the very real financial implications of having knotweed on or even near your property. So in this situation, we have Mr. Davies, who purchased a property, and surprise, surprise, it came with a side of Japanese knotweed.
Oh no, not the housewarming gift anyone wants.
Not at all. And to make matters worse, the knotweed was actually encroaching from a neighboring property owned by, you guessed it, the local council.
Of course. It's always the council, isn't it? So what happened? Did Mr. Davies just accept his fate, or did he decide to take on the council?
Oh, he took them on, all right. Over time, as you can imagine, the knotweed spread, and it caused damage to his property, impacting the value of his home, and I'm sure causing a great deal of stress. He was understandably frustrated and decided to sue the council for not controlling the knotweed on their land.
So a classic tale of the nuisance neighbor, but instead of loud music, it's an invasive plant wreaking havoc. What did the court have to say about this? Were they sympathetic to Mr. Davies' plight?
Well, the court actually ruled in Mr. Davies' favor on this one. They agreed that the council was in the wrong, that they did have a responsibility to manage the knotweed on their property, and because they failed to do so, yeah, they were liable. But, and this is a big but, the court said that Mr. Davies couldn't claim for the entire loss of his property value.
Ooh, how come? If the knotweed was ultimately coming from the council's land, why wouldn't he be entitled to the full amount of the decline in his property's worth?
Right, so this is where it gets a little bit tricky and goes back to a point we were talking about earlier about how these cases often hinge on some very specific legal concepts. In this instance, it comes down to continuing nuisance, which was established in a previous case, Delaware Mansions, if you recall that one, which dealt with damage caused by tree roots.
Yes, I'm vaguely remembering that one now.
So the Davies ruling essentially clarified how this idea of continuing nuisance applies in situations like this with ongoing issues like knotweed. See, because Mr. Davies knew about the knotweed when he purchased the property, the court determined that he had sort of implicitly accepted some degree of risk. They essentially drew a line in the sand, saying the council was only liable for the portion of the damage that happened from the point at which they should have reasonably acted to remedy the situation.
So, a partial victory for Mr. Davies, but a significant clarification of the law nonetheless. It seems like timing really is everything in these nuisance cases.
Absolutely. You really need to be able to draw that direct line from the nuisance to the damage to prove that cause and effect relationship and to do it within a specific time frame. When did the nuisance begin? When should the responsible party have taken action? All very important questions.
It makes you realize how important it is to keep good records, right? If you find yourself in a situation like this, you need to be documenting everything. Photos, dates, detailed notes.
Oh, absolutely. Those records can be absolutely invaluable, especially if you end up needing to take legal action. And speaking of expert advice and how that plays into these cases, remember in the Davies case how the court's decision really hinged on that question of when the council should have acted to control the knotweed? Well, back in 2022, the Royal Institution of Chartered Surveyors, the RICS, you know them.
Yeah.
Well, they released new guidance on assessing knotweed risk, kind of trying to standardize that process.
Well, we've gone from sewage-laden canals to battling invasive plants. It's quite a deep dive today. But two very different nuisances, two very complex cases. But I feel like there are some really important common threads here. What do you think the average person listening to this, what should they be taking away from all of this?
It really boils down to this. Knowing your rights as a property owner here in the UK is absolutely crucial. You know, whether it's something as, disruptive as sewage pouring into your property or as, we'll say, persistent as Japanese knotweed slowly encroaching, you really need to understand what your rights are and what options you have if you find yourself in one of these situations.
Right, because hoping for the best, that only gets you so far, right?
Yeah.
You need to know what you're actually entitled to and what you can do if someone is, impacting your property, even if it's unintentional.
Exactly. And just as importantly, being able to prove it. That's huge, like we were talking about, especially with these cases of what they call continuing nuisance, like that knotweed situation. You have to be able to connect the dots. You need to show without a doubt that whatever the nuisance is, it directly led to some quantifiable amount of damage on your property and that it happened within a specific time frame. All of that is crucial if you're going to build a strong case.
So documentation. That's what I'm hearing. We're talking photos, dates, times, detailed notes. It's not enough to just sort of remember that something happened. You've got to have a record of it.
It's true. Those records, they can make all the difference if you ever do need to take legal action. And actually, speaking of, expert advice and how that plays into these cases, remember how in the Davies case, the court's whole decision kind of revolved around when exactly the council should have stepped in to deal with the knotweed?
Right, yeah.
Well, remember back in 2022, the Royal Institution of Chartered Surveyors, RICS, everyone probably knows them by now.
Yeah.
Well, they put out this new guidance on assessing knotweed risk, sort of trying to standardize the whole process.
Oh, yeah, that's right. I remember when that came out. It's interesting, isn't it? It makes you wonder, I mean, could this shift in how, the professionals are approaching knotweed, could that actually end up influencing how the courts interpret the law down the line?
Yeah.
Could it change how these cases are decided in the future?
You never know. It's definitely something to keep an eye on. As we learn more about invasive species like knotweed, and as those professional practices start to adapt, it's entirely possible that the legal side of things might shift as well.
It's a fascinating thing to consider. And on that note, I think we'll leave our listeners with that thought. Thanks for joining us for another deep dive. See you next time.